Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series talking about the SEC's proposed rules to modernize and simplify disclosure requirements for public companies, investment advisors, and investment funds. Today, I am going to give a brief history of the SEC Disclosure Effectiveness Initiative. In early December 2015, the FAST Act was passed into law. The FAST Act required the SEC to adopt or amend rules to allow issuers to include a summary page to their Form 10-K and scale or eliminate duplicative, antiquated, or unnecessary requirements for emerging growth companies, accelerated filers, smaller reporting companies, and other smaller issuers under Regulation SK. The current Regulation SK and SX amendments are part of this initiative. In addition, the SEC was required to conduct a study within 1 year on all Regulation SK disclosure requirements to determine how best to amend and modernize the rules to reduce costs and burdens while still providing all material information. That report was issued on November 23, 2016. Prior to that time, the SEC and various market participants have been talking about needed changes. In March 2015, the American Bar Association submitted its second comment letter to the SEC, making recommendations for changes to Regulation SK. And in September 2015, the SEC Advisory Committee on Small and Emerging Companies met and finalized its recommendations to the SEC relating to changes to the disclosure requirements for smaller publicly traded companies. As we have talked about during this Lawcast series, on April 15, 2016, the SEC issued a concept release and request for public comment on sweeping changes to certain business and financial disclosure requirements, followed by proposed rule changes, which were issued on July 13, 2016, and are slated for action this year. As part of the same initiative, on June 27, 2016, the SEC issued proposed amendments to the definition of a smaller reporting company. The SEC also previously issued a release related to disclosure requirements for entities other than the reporting company itself, including subsidiaries, acquired businesses, issuers of guaranteed securities, and affiliates. Both of these items are also slated for action in this year's SEC's regulatory agenda. On August 25, 2016, the SEC requested public comment on possible changes to the disclosure requirements in Subpart 400 of Regulation SK. Subpart 400 encompasses disclosures related to management, certain security holders, and corporate governance. On March 1, 2017, the SEC passed final rule amendments to Item 601 of Regulation SK to require hyperlinks to exhibits in filings made with the SEC. The amendments require any company filing registration statements or reports with the SEC to include a hyperlink to all exhibits listed on the exhibit list. In addition, because ASCII, which is a type of computer code, cannot support hyperlinks, the amendment also requires that all exhibits be filed in HTML format. The new rule went into effect on September 1, 2017. However, non-accelerated filers and smaller reporting companies that submit filings in ASCII may delay compliance through September 1, 2018. Finally, as covered in this Lawcast series, on October 11, 2017, the SEC published proposed rule amendments to modernize and simplify disclosure requirements for public companies, and investment advisors. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.